Let me ask you a question. We're now at trial. It's a medical malpractice trial. Do you think that if an attorney admits to the jury that his client did something wrong, do you think that that goes ahead and bolsters his client's credibility as well as the attorney's credibility, or does it show weakness? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney, and the answer is it could do both. Let's say there's something bad that happened to my client, and now she's afraid of getting that out in front of the jury. Well, I'll tell you something. One great trial strategy is to get ahead of the problem, to address it before the defense has an opportunity to address it. So let's say, for example, my client was convicted of some horrible crime years earlier, and now I keep quiet about it. I don't say anything, hoping that the defense lawyer ignores it or doesn't even know about it. Well, I'll tell you something. That is a horrible strategy. You want to know why? Because I guarantee you with 100% certainty that the defense lawyer knows that my client was convicted of some horrible crime. And if I don't mention that at the very beginning of the case, I guarantee you the defense lawyer is going to do everything possible to tell the jury that we're hiding something very significant. They're going to spring it on the jury and basically turn to us and say, look at what Oginski's hiding. Look at what his client is hiding. That's not the right way to do it from our standpoint. Instead, the better practice is to use it to our advantage, to come right out to the jury and say, listen, ladies and gentlemen, my client did something horrible, 20 years ago, and they were punished for it. They went to jail, they did their time, and now here's what that involved. And I'll tell them briefly what happened. And then I'll say, listen, but that has absolutely nothing to do with the claims being made in this case. It has absolutely nothing to do with what this patient said to the doctor and how the doctor misdiagnosed my client. So the whole goal is to get that out in front. And yes, it's a damaging thing. Yes, it has to be addressed. And yes, it better be done before the defense has an opportunity to go ahead and mention it, to say that we're hiding something dramatic. If we don't mention it, we're hiding it, it's going to destroy our credibility, mine as well as my clients. So much better to turn around and to use it to our advantage, get it out in front first, admit it, own up to it, and turn it around and say, listen, we understand this was bad, this was horrible, and we don't make any excuses for what he did. But that's 20 years ago. We're talking about something that happened 2 years ago with this doctor, claims that he violated the basic standards of medical care, claims that he suffered permanent injury because this doctor was careless at a particular day, at a particular time. That's the better strategy. So why do I share this quick information with you? I share it with you just to give you an insight and an understanding into what goes on in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I understand you're watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but have not done so yet because you still have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.